Let's go with witnesses. Okay? Qualifications of witnesses. Kahit sinong tao, as long as you are able to, or you can perceive or make known your perception, you are qualified to be a witness. Bulag, pwede ba siya maging witness? Yes, pero dun lang sa mga bagay na narinig niya. Okay? Pero syempre hindi pwede sa nakita kasi nga bulag siya. Okay? Always remember that we have 5 senses. Okay? Yung kung bulag ka, pwede mong i-avail yung other senses mo, like your smell, sense of smell, yung feeling, taste, yung mga ganyan. But of course, since bulag ka, you cannot use your sense of sight. In that case, okay, you are not able to make know your perception. In that case, kung nakita, you are disqualified since you are blind. Pero yung mga narinig mo, na-feel mo, mga natikman mo, na-amoy mo, okay, you are qualified as a witness even if you are blind. Okay? Disqualifications of witnesses. Okay? Your new rule. Okay? May bagong rule tayo. The 2020 rules or the amendments of the evidence, okay, have abolished the following witness disqualifications. Number 1, those who are mentally incapacitated and immature children. Na-abolish na to. And number 2, those that bar against claimants against the state of deceased person or against an insane person from testifying on antemortem or pre-insanity facts. These are already abolished po. Okay. Again, if you are not writing down at the moment, that's okay. I will just give you the copies. I just want you to, ang gusto ko lang is na-refresh yung mga na-review ninyo. Also, remember in your child witness rule, okay? Rule of examination of child witness, okay? Under section 6, okay, every child is presumed witness to be a qualified witness. However, the court may conduct a competency examination if substantially doubts exist as to the child's competency to testify. We have this so-called dead man's rule. Okay? Ano to? Dead man's rule. Under Rule 130. Okay? A party having a claim or demand against the state of a deceased person or against his executor or administrator cannot testify as to the fact occurring before the decedent's death. Okay? Yung section 23 ng Rules of Evidence natin, Rule 130, okay, it was abolished by section 39 of the Rule 130 because it is now already provides na, okay, yung claimant can already testify on ante litem. Okay? Sorry. I would like to ulitin ko. Yung section 23B4 ng Rules on Evidence is already abolished by section 39 of Rule 130. The framers of the 2020 rules felt like yung dead man's rule would result to injustice to a claimant who would be helpless to pursue his claim if he does not have any outside witness or written proof. Okay? Na-realize ng framers ng batas natin na yung dead man's rule is there is an injustice to such rule. So, it would bar the claimant to present any evidence against the estate of the deceased person. So, the same consideration shall be applied to the abolition on the bar against testimony of pre-insanity facts. Since the same ang rule sa mga deceased person, they also felt like it should be applied also to those who are pre-insane or yung mga matino noon pero baliw na ngayon. So, yan. Marriage disqualification rule. Okay? Marriage disqualification rule versus marital communication privilege. Yung marriage disqualification rule provided by Section 22 of Rule 130. Yung marital communication privilege is Section 24 of the same rule. Okay? Yung bagong update ng Rule 2020, okay, it deleted the word for, okay, after testify. So, ngayon, the new rule is this. During the marriage, okay, during the marriage, a spouse cannot testify. A spouse cannot testify against the other except in a civil case by one against the other or a criminal case committed by one spouse against the other or other ascendants or descendants. Again, na-delete na po yung for, so hindi na siya pwedeng mag-file in behalf of the other spouse. A husband can no longer object if his wife will testify for him. Okay? Always remember po na marriage must be existing at the time of the offer of the testimony, even if the marriage occurred after the facts sought to be testified to. Sample po natin is the case, okay, of Lezama versus Rodriguez. Here, where the husband and the wife were charged with having colluded to defraud the plaintiff, parang kinasuhan yung mag-asawa kasi dinefraud daw nila yung nagkaso. Let's just say Pedro. Okay? Here, the wife cannot be called as an adverse party witness by the plaintiff over the husband's objective. There are many privileges under the rules on evidence. Okay? We have the marital communication privilege, attorney-client privilege, physician or psychotherapist patient privilege, and the priest or minister privilege, and the public interest privilege. On the first privilege, okay, the marital communication privilege, always remember po that the husband and the wife, example, si Pedro at si Ana ay mag-asawa, okay? Si Pedro o kaya si Ana, they cannot be examined without the consent of the other. Kasi they are regarded as one, di ba, sa batas natin. Okay? The husband or the wife, Pedro or Ana, cannot be examined without the consent of the other as to any confidential communications received from the other during the marriage. Okay? Of course, there is an exemption. If there is a civil case by one against the other, pag sila lang ang nagkakasuhan from each other, of course, this privilege will not apply. Okay? Common sense will dictate us, of course. So, unlike the marital disqualification rule, the marital communication privilege will still hold even after the marriage has been terminated. Yung marital communication privilege po, still apply kahit maghiwalay na sila, kahit na-annul na yung kasal nila. Yung marital disqualification rule, kailangan kasal sila at the time the testimony is offered. Okay? Next one, attorney-client privilege. Okay? Because one of the obligations and duties of a lawyer is to uphold the confidentiality rule. Siyempre, hindi naman po namin pwedeng basta-bastang isiwalat yung mga nasabi sa amin. Kahit sabihin sigurong, attorney, okay lang kayang bombahin namin yung tugigaraw. That is not okay. In that case, pwedeng maging exemption yun dito sa attorney-client privilege, okay? And, of course, this privilege It also covers yung secretary ng lawyer, stenographer, clerk, security guard, janitor, okay, investigator, or accountant. They cannot be examined without the consent of the client and their employer. Can the lawyer reveal secrets para lang makakolek siya ng fees? Sabi po ng rule namin. Lawyer may, okay? The lawyer may reveal secrets when necessary to collect fees or to defend himself, his associates, or employees. Other exemptions. Di ba yung sabi ko nga sa inyo, ang sinabi ng client, attorney, pwede ko bang bombahin yung tugigaraw? Pwede ko bang saksakin yung asawa ko? Pwede ko bang sabunutan yung kapitbahay namin? Sabi ng batas, okay, if the client asks for the opinion or the help of the lawyer for furtherance of crime or fraud, okay, so pumunta siya sa abogado para lang i-check kung yung niya, it will be used in furtherance of crime or fraud. This is the so-called future crime or fraud exemption rule, okay? Baka lumabas to sa board exam niya, okay? If the services or the advice of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit what the client knew or reasonably should have known to be a crime or fraud, that is an exemption to the attorney-client privilege. In that case, pwedeng sabihin, pwedeng i-report nung attorney. Also, if the claimants through same deceased client, that is an exemption. Example, si Ana at saka si Ben are magkapatid. Okay? Their father, si Pedro, hired attorney, sa example, attorney Ballad. Okay? So, si Pedro, may anak siya, si Ana at saka si Ben. Si Pedro, hinire niya ako to draft a will, last will and testament. Kaya namatay si Pedro. Okay? Now, si Ben wants to show that their father intended na yung lote sa Sanchez Mira belongs to Ben. Okay? Here, the attorney hired by Pedro, can testify that the father intended to devise the lot in Sanchez Mira to Ben as shown by the will. Of course, another exemption is when there's a breach of duty by a lawyer or the client. Another one, a case where the client alleges, kaya sabi ni Pedro, ay nakanginginang mat at the lawyer's fee attorney, kaya imbagam ko mga kasta kangina, sabi niya, nanalo sila ng case, okay? Here, yung lawyer can disclose relevant communications to show that the case was complex and difficult, thus justifying higher fees. Ang pag-measure po kasi ng acceptance fee or lawyer's fee or attorney's fee is nasa difficulty po ng difficulty of winning the case. Okay? Kung mas madali, of course, mas mababa yung charge. Kung mas mahirap, mas mataas po. Another one is a document attested by the lawyer. Example, ako, attorney, was the attesting witnesses to a will. Okay? In a probate case, the lawyer may testify regarding the attendant circumstances to the execution of the will in order to show that the testator was of sound and disposing mind. And lastly, this the joint clients. Don't worry, we're almost done. Dinidiscuss ko lang po yung mga possible na lumabas sa board exam niya with regards to evidence. Next one is the physician psychotherapist patient privileges. Okay? A psychotherapist is a person licensed to practice medicine, engage in diagnosis or treatment of mental or emotional condition. It is also a person licensed as a psychologist by the government while similarly engaged. Okay. This physician, psychotherapist, patient privileges, okay, only applies to civil cases. Okay. Law and order considerations override the privilege in criminal cases. So, yung mga autopsies conducted by medical legal officers are not privileged. Okay, as there is no patient involved. Bakit? Kasi patay naman po yun. Okay? Ang autopsy, kinakandak lang yung pagpatay. Alam na alam niyo yan kasi kayo ang laging gumagawa niyan, mga crime student. Okay? Of course, pati yung sa priest and or minister's privilege. Okay? Almost same yung application niya dun sa lawyer, attorney privilege. We have this so-called executive privilege. Okay? It is a privilege which protects the confidentiality of conversation that takes place in the president's performance of his official duties. This privilege may be invoked not only by the president. So, example, today, it's President Duterte. Okay? The privilege may be invoked not only by President Duterte but also by his close advisor. You know his close advisor, Bongo. Okay, under the operational proximity test. That is the case of Neri versus Senate Committee. Okay. We have a new rule with regard this one. Okay, the executive privileges. This privilege is not lost if the communication falls into the hands of third person, okay, who provide reasonable precaution. Yun ba. Next one is the testimonial privilege. Take note that in testimonial privileges, okay, these privileges this privilege is for the witness and not of the adverse party. Okay? Hence, the adverse party example, okay? Yung tatay, he cannot object if his son wants to testify against him. Yung anak, however, may not be compelled even by the court to testify against his father if he does not want to. Next one is the parental or filial privilege. Here, okay, no person shall be compelled to testify against his parent, other direct ascendants, children, or other direct descendants, except when testimony is indispensable in a crime against the person or by parent against the other. This is provided in your Rule 130, Section 25. May bago po tayong rule dyan sa parental and filial privilege. Okay? In the 2020 rules adopted from Article 215 of the Family Code, okay, that the criminal case exemption to the privilege. Note that the witness's testimony must be indispensable. If the testimony is only corroborative, hindi very important, the parental and filial privilege still upholds. We go to extrajudicial admission and judicial admission. Extrajudicial admission is provided in Rule 130, while judicial admission is provided in your Rule 129. Extrajudicial, from the word extra, it is outside the court. Okay? It is not conclusive on admitter. Okay? Pero yung judicial, it's conclusive on admitter because he made his admission within the court's jurisdiction. Okay? And of course, an extrajudicial admission hindi siya conclusive, so it should be proven. Yung judicial admission, since it is conclusive na, hindi mo na kailangang i-prove. Okay? Admissions, there are three forms. It can be an act, statement or declaration, or omission. Example ng acts, okay? Example, when you voluntarily participate in the reenactment of a crime, okay? when you flight from the scene of a crime, pag nagpalit ka ng anyo mo o yung pangalan mo, okay, those are admissions by act. When you transfer your property, when you attempted to bribe the witnesses, those are admission by act. How naman yung admission by statement? Ay, wait lang. In civil cases po, okay, an offer of compromise is not an admission of liability. Sa civil cases, example, utang, okay? 'Di ba? Some collection of sum of money. An offer of compromise. Gusto mo nang makipag-ayos, ikaw yung hindi nagbayad ng utang. It is not an admission of liability. It is not also an admissible evidence against the offerer. Okay? Neither is the evidence of conduct nor statements made in compromise negotiations admissible. Next one. Wait lang pa. An extrajudicial confession is binding only upon the confessant, okay? Even if it implicates others in an alleged conspiracy, if there is no proof of conspiracy aside from the extrajudicial confession. That is the case of Tamargo versus Awingan. So, for example, the accused confession to a radio broadcaster, nag-confess siya sa Bombo Radio, okay? That is admissible in evidence. He was not entitled to the Miranda rights as he was not under custodial investigation. Another is the accused Miss Fit Chira, can you turn off your mute, mag-mute po kayo. Ayan, ako na lang. Okay. So, for example, pag nag-confess ka naman sa news reporter while in police station, it shall be admissible and evidence against you. Last is the similar acts rule. Okay. Evidence that one did or did not do a certain thing at one time is not admissible to prove that he did or did not do the same or similar thing at another time. But it may be received to prove the following. It can be a plan, identity, knowledge, intent, custom, habit, usage, system, and the like. Ang shortcut po dyan is picky choose. Ayan, kung hindi nyo makalimutan. Last topics are the hearsay rule. Okay, yung mga hearsay rule pa. What is a hearsay? A hearsay is an out-of-court statement which offered for the truth of a matter asserted therein. Okay? Under the hearsay rule, hearsay is generally inadmissible. Under the hearsay rule, ang hearsay po is inadmissible, so hindi siya tatanggapin ng korte in evidence except unless it falls within any of the exemption to the rule. We have the so-called independent relevant statement. Okay? An independent out-of-court statement is one which is relevant not for the truth of a matter asserted therein but for something else. Example po nito is yung mga intent, yung mga belief, yung mga motive, yung mga mere fact of utterances, yung mga legal effects, mga ganyan. What is the rule of thumb? Okay? The rule of thumb to determine if a statement is independent, relevant. Okay? Ang rule natin is, itong question, tanungin nyo. Okay? Independent relevant statement, ARS. Would the statement have probative value even if false? If the answer is yes, then that is IRS. Question. Case na lang tayo. Okay? For the prosecution of rape, Dr. Mijares examined the victim, Ana, okay, and executed a medical report on his findings. At the scheduled hearing, si Dr. Mijares appeared after several subpoenas and warnings from the court. But instead of presenting him to be examined on his medical report on the alleged rape of Ana, yung prosecutor, he manifested that she was dispensing with his testimony provided the defense agreed to the prosecution's offer of stipulation that Ana submitted herself for medical examination 1 week after the alleged rape, to which the defense acceded. Is the medical report a hearsay? Obviously, it's a yes. Here, since Dr. Mijares did not testify in court regarding the same, diba? Actually, okay, in this case, this is the case of People versus Rondina. Okay? That the stipulation was not on the truth of the contents of the medical report but only to the fact that AAA submitted herself. Okay? Since it's only the doctor who can prove the same, anything, okay, na hindi proven, that is considered to be a hearsay. Next one. Dying declaration. Okay? Section 38, dying declaration. This is the exception most commonly as in any exam. Okay? The dying declaration is always applicable to civil and criminal cases. The following are the requirements. Number 1, that the declarant should die. Number 2, that death is the subject of inquiry in the case. Number 3, declarant conscious of impending death. Number 4, the declarant relates to cause and circumstances surrounding the declarant's death. Number 5 is that declarant must otherwise be competent. So, for example, if the declarant said, one said it was Pedro who shot me, here the declaration is inadmissible for being a hearsay. Okay? In dying declaration, it does not matter whether the declaration is against or in favor of the accused or the adverse party. Okay? Question. Wait lang. Maghanap lang ako ng maganda. Yung ano naman yung pedigree, hindi naman tinatanong to. I'll just skip this one. Res geste. Okay? Part of res geste, section 44. Okay? These are statements made by a person while startling occurrence is taking place or immediately prior or subsequent thereto, under the stress of excitement caused by the occurrence with respect to the circumstances thereof, may be given in evidence as part of the res geste. In the new rule, ang bagong rule po natin, the amendment added the requirement that the excited utterance or statement was made under the stress of excitement caused by startling occurrence. So, binago po yung ng batas natin to, bago. So, what is the rationale for this part of res geste? Okay? There's a high level of reliability. Mataas yung reliability ng mga statements if that was made under the influence of startling occurrence. Kasi biglaan nga po. So, the statement becomes part of the res geste. It is the event happening through the person rather than the person speaking about an event. So, ang rule natin dyan is this one. If the statement is nagawa or nasabi was made at the time of or immediately before or after the startling occurrence, okay, it may be presumed that it was made under the stress of excitement caused by the startling occurrence. Okay? But if it is removed in time from the occurrence, there must be showing that the declarant was still under the stress of excitement. Okay? pa ba? May mga, dito, may mga examples, and I'll just give it to you. Bibigay ko na lang kay kay Sir Melvin. Yan. So, I just highlighted the important topics po sa evidence. I hope na may natutunan kayo na kaunti, and na-refresh ko po yung mga na-review ninyo. Yung mga examples na iba, andito, maiksi lang naman po yung reviewer na ibibigay ko. So, just read if you have time. This, updated po to. So, don't worry, updated po ito. And it is actually a bar material. So, please do not reproduce it or do not upload it online. Okay? Thank you for listening po. And have a nice day.